I think we'll kick off then. So good morning, everyone. Thanks for joining us today. Just brief introductions. So I am Alexi Markham. I'm a partner in the commercial IT and outsourcing team at Gowling. And my particular area of focus is central government procurement and contracting in the wider public sector. Full disclosure, I've got a particular interest in the standard contracts because back in 2013, I was seconded to the Cabinet Office to help develop what was the original model services contract. I'm joined today by Chris Brennan, who is our resident procurement expert, and Chris is going to be touching on updates to the procurement bill at the end of the session. Just a little bit of housekeeping. The session today is being recorded and we'll circulate a copy of that to everyone that's on the call after the session, and it will also be available on the on-demand section of our website. There is a function so you can put questions in the chat as you go along, and we'll try to pick those up at the end. And equally, there's a chance to give feedback at the end of the session. So if you've got any suggestions and things you would like covered in future sessions, we're always for that sort of thing. So in terms of what we're going to look at today, obviously the standard contracts is the topic. So first of all, we thought it'd be helpful just to give you an overview of the three standard contracts, and we'll be looking at which contract you can use in which situation. We'll also have a look at the other documents that you need to be aware of and have recourse to when you're using the standard contracts. And then what we're going to do is turn to each of the contracts in turn and just pick up on some things around the structure and some of the key features in those contracts. But then going to look at PPN 0823, which is the PPN released in August around the standard contracts, and touch on what's new under that PPN. And then finally, we'll get to the meat of the session, which is really looking at what the updates have been to the standard contracts. And we'll look through the key themes that come through on each of the contracts, but we'll then focus on some of the key commercial provisions, so intellectual property, termination, indemnities and liabilities. And compare and contrast the positions between the three different contracts. And then, as I said, finally, I'll hand over to Chris to update us on the procurement bill. So, overview of the three standard contracts. So that there are three standard contracts, and they're each of ranging length and complexity. In terms of which contract you should be using, the key drivers really around the value, complexity and risk of the project or the procurement that you're looking at. I mean, there are other factors that you need to consider as well, which would be things like the capability of the market, but value, complexity and risk are sort of the key things. At the top and end of the spectrum, there is the model services contract, and this is like the most comprehensive contract in the suite. Those of you that have picked it up before know that it's a bit of a beast, so you really don't want to be using it for sort of low value, low risk procurements. It's primarily aimed at outsourced services, and that's really due to the way it sort of originated. But the guide from the Cabinet Office in terms of its use is that you're looking at procurements with contract value of over 20 million and or a particularly high risk or critical service involved. And typically where we see it used is on procurements which require some sort of formal dialogue with the market or negotiation with the market. At the other end of the spectrum, we've got the short form contract, which as it sort of indicates is a lot shorter, and that's for general goods and services procurements where the contract value is below the relevant procurement threshold. So for central government, we'd be looking sort of below 138,000. I guess the exceptions to that is if you've got a requirement that might be low value, but you've got a bit of a more complex requirement or critical services, and that might push you up into the mid-tier contract. Which brings us nicely onto the mid-tier contract. So straddling the two, we've got the mid-tier contract, and again, this is for goods and services. And the value that that particular contract's aimed at is ones that are above the procurement threshold but less than 20 million, and it's looking at sort of requirements that are bespoke or semi-complex, and for all of them it's looking at things that you can't buy off existing government frameworks. So this slide just picks up on the evolution of the contracts over time. And along the top, we've tried to plot events that impact or change government policy. And then at the bottom, we've charted the various updates to the standard contracts. So the original contract was the model services contract, and that originally was drafted back in 2013, but there's been about 10 updates to that since that point. The mid-tier contract came along in December 2019, and that's had a couple of updates since, so in April 22 and August 23, and then the short form is relatively new, so that came out in September 22, and then the update that we've just had in August is the first update to that. I think the key takeaway point really from this slide is that the contracts are a really good barometer for government policy and ways of working at the time. So if you do use them, you can feel confident that the contract that you're using reflects up-to-date government policy. And then the other key takeaway is just that there really are an evolving suite of documents, so they're under constant review and updates as legislation and policy changes. The standard contracts aren't a standalone set of documents, but actually they're part of a much wider suite of government guidance and policy, and that's what we've tried to set out in this particular slide. Along the top of the slide, the standard contracts itself, and for each standard contract there's a guidance notes focusing on particular key terms, and then under that at the bottom of the slide we've got the documents that contain the underlying policy. So the key policy documents, I would say, are the playbooks, and in particular the sourcing playbook and the digital data and technology playbook, and of course with each of the playbooks there's a whole raft of supporting guidance notes, some of which would be particularly relevant for the contract, so that there is a separate guidance note on financial distress provisions, for example, or intellectual property rights. We've also got the supplier code of conduct, and that really outlines the standards and behaviours expected from suppliers. And then we've got the PPNs, which are the updates to policy that get released throughout the year. Okay, so turning now to look at each of the standard contracts in a little bit more detail, and looking firstly at the model services contract. We touched on its use, so we're looking at high value, high risk, high complexity requirements. In terms of the structure, it's what we would refer to as a traditional structure, which means it looks a lot like you would expect a contract to look. So you have a front page with the parties, you then have a full set of terms and conditions and a raft of schedules sitting behind that, and there's 32 different schedules for the model services contract. Key features, I think, for this one that aren't in the other one, there is really quite detailed regimes in here dealing with financial distress and corporate resolution planning, so how you monitor the economic financial standing of suppliers, and how you might put in plans to mitigate financial risks identified, and equally the resolution planning pieces around how do you reduce the impact of supplier insolvency by looking and understanding about how the supplier is backed up by its group of companies. So that's kind of unique, I think, to the model services contracts. Then there's also quite a detailed regime to do with implementation, so the model services contract assumes that there'll be quite an involved process in order to get ready for service go live. So there's processes and controls for building and adapting and implementing services. And equally, there's ready to go drafting around testing, including test and acceptance criteria. The mid-tier contract then, so this is for below 20 million, but above procurement threshold contracts. And the structure here is actually modular, and by that we mean there's a series of different documents that need to be populated, and together those form the contract. So the first of those documents is the award form, and that essentially is where you populate a lot of the key commercial details, so things like the party names, contact details. You might put things like the charges in, or you might put them in a schedule, but importantly it has a list of the schedules that you want to incorporate, so you tick those in the award form. There's then a separate document containing the core terms, which are the legal terms and conditions that were applied to the contract, And then there is up to 37 additional schedules, 12 of which are mandatory and 25 of which are optional. And as I said, with the optional ones, you just need to select which ones are applicable in the award form. There is some really useful guidance in the guidance notes for the mid-tier contract around the schedule. So I'd recommend you have a look at that if you're not sure about which schedules you should be including when. So it explains what each of the schedules do, and it explains the circumstances in which you should include them. And then finally, the short form contract. So this is really for fairly off-the-shelf, non-complex goods and services below the procurement thresholds. And again, it uses a modular structure. This one has a cover letter, so it's a letter to the supplier explaining how the contract is formed, and obviously that's designed to be SME friendly. It has a contract order form, which is the equivalent of the award form in the mid-tier contract, and that again is where you populate the key commercial terms, and that's the document that you really need to prepare prior to tender for this contract. And then it has a short form terms and conditions, and then up to 5 annexes, one of which is mandatory, which is the data protection annex, and then the 4 of which are optional depending on your requirement, and those are specification charges, the supplier tender, and then some options around intellectual property rights. I think the important thing to probably flag about the short form contract is that it assumes that there's not going to be a 2P transfer on entry or exit, and because of that, it's not really suitable for outsourced services because 2P tends to be relevant there. The other thing is the acceptance criteria aren't covered. So if you need some sort of detailed sign-off process before services go live, then you're probably looking at the mid-tier contract or the model services contract. So PPN 0823, which is called Using Standard Contracts, this came out in August of this year, and it applies to all central and government departments, their executive agencies and non-departmental public bodies. In terms of what it says, it gives us a fairly clear direction that we should be using the standard contracts as default, but there are a couple of caveats to it, and that is if there's a suitable framework, which is obviously where quite a large proportion of government and public sector spend is made, or the other alternative is if there's a more suitable alternative agreement in existence, and the specific examples that were given there are things like departmental terms and conditions for really low value spend, or a industry specific contract, so something like a construction contract. The aim of the PPN and the standard contracts is set out in the PPN, and that's really about sort of creating efficiencies and reducing costs. And that's both on the authority side, because obviously there isn't a lot of point in reinventing the wheel and increasing negotiation and resource time, but also on the supplier, so that they're very cognizant that for SMEs it can be quite difficult to sort of tackle a whole range of different contracts from different departments and different public bodies, and so by harmonising the terms across these bodies, then it creates more of a level playing field. The other key aim is just to make sure that you've got a consistent policy position across the contracts. And I think this is an important one because it is slightly odd sometimes when you see some of these key commercial positions and they vary between public body to public body. So I think that's an important aim. And the mandate for adopting these contracts is as soon as practicable. Right, so that brings us on to the updates and what is new. Just before we dive into the detail, I think it's kind of helpful to understand the process the Cabinet Office has gone through to do the updates. Usually the updates just pick up legislation and PPNs that have been released during the year, but actually this year there has been a consultation with industry, so there were a series of roundtables in September and February of 23, and then there's also been a call for views, so people have been able to feed in addition to those roundtables, issues and concerns that they have with the standard contracts. So the key themes in terms of the updates across the 3 contracts. Firstly, legislation. So as I just touched upon, it's picked up new laws in the year, which is primarily around changes to GDPR, and it's picked up the PPNs that have been released during the year, and we'll come on to what those are in a second. The second key theme is around simplification. So there's been a real effort to try and make the contracts more user-friendly, and I think that will be welcomed both by the suppliers and the public sector. In terms of how that has been done, there's been efforts to shorten the short-form contract and the mid-tier contracts. There's been unnecessary definitions removed, and those clauses have been amalgamated, and there's been an effort to try to group together terms that relate to each other. So an example there would be around the supply chain flow down. So I think all of that is to be welcomed. Harmonisation. So there has been a push to align key positions across all 3 standard contracts, including in relation to liability, indemnities and termination. And we're going to come on to that in a minute. There has been updates to policy from policy documents released during the year. So the sourcing playbook and the digital data and technology playbook in particular. And the key things really that have changed there is around indexation and the approach to IPR. And again, we're going to come on to those in a minute. And then finally, there's been some updates to Schedule 7, which is the staff transfer schedule. I'm not going to go into these in any detail because I'm not a 2P lawyer, but I've set out on the slide the key things that have changed or been considered by the Cabinet Office. So PPN updates. On this slide, we've just set out the 3 PPNs that have come out this year that have had an impact on how you draft your contracts. And I thought this would be helpful to capture just in case you've got your own contracts that you need to update. So the first one relates to where you're directly or indirectly procuring steel. So I suspect not most contracts, but this is really all about how you report on your annual steel data return. The second one will apply to much more contracts. So it's about modern slavery and making sure that you use the guidance tackling modern slavery in government to identify modern slavery risks. And then the final one's around data protection, and it's really looking at the changes required to the data protection provisions post-Brexit, and there's a bit of a renewed focus on data security. Right, so at this point, we're going to move to focus on the core meat, and rather than looking on a contract by contract basis, what we've chosen to do is look across the suite of contracts and pick up on some of the key commercial positions. So look at things like indemnities across each of the contracts and compare and contrast what the contracts say. And I think that this is an interesting exercise to do at this point, because we know that the positions now that are in the contracts are the result of consultation with industry and deliberation by the Cabinet Office. And accordingly, it's affirmative of what the government policy is on particular key areas. And I think in the past, what we found is where there's been variance between the different contracts, there's been a bit of question as to why. So is it just a hick in the drafting, or is it because of the fact that the contracts are of different values? And now actually we've got an answer to that question. And there are a few areas which are particularly contentious for suppliers. So anything that has a subjective termination right, for example, we get a lot of feedback on. So it's quite interesting to see where they've landed on those types of rights. Just by way of health warning, there is quite a lot of information in the next few slides because of the nature of the exercise we're doing, but I thought it would be quite helpful to have that information, and we will circulate the slides after the presentation so that you've got them as a reference material. Right, so topic number 1, liability caps, and looking at the suppliers first, which is obviously the more complicated side of the equation. So in terms of what is new from a policy perspective in this area, we have a general policy which is set out in the sourcing playbook, and that is that suppliers should no longer be expected to take on unlimited liabilities, and that is a bit of a step change from the approach 10-15 years ago. But there are an exception to this general rule, which is a small number of incidents where would either be illegal to cap liabilities, or where there is a commercial cross-government policy that has been agreed. And the Sourcing Playbook also stresses that we shouldn't be asking for disproportionate liability caps. In terms of this, how this then translates into the contracts, what we've done on the slide is sort of set out the three main pots of liability. So we have one pot for unlimited liability, one pot for super caps, and one pot for general caps. So taking unlimited liability first, as we said, these are types of claim that you can't limit under law, so things like death or PI caused by negligence or fraud. And then there are the types of liabilities where government has deliberately left things uncapped, which is things like intellectual property claims, 2P claims, non-payment of taxes, or claims relating to supplier staff. And the position is the same across all of the contracts, other than on the short form contract. You don't have the 2P related claims sitting within this pot, because there is no 2P anticipated under the contract. The next pot as such is the super caps. The first that sits within that is data loss or GDPR breaches. The exact level of the cap required is to be determined by the authority on a case-by-case basis, but there is quite a lot of guidance in the various guidance notes to the contracts now about the range of factors that people should be taking into account. So things like the sensitivity and the volume of the data in the contract. And a base figure is given for each of the contracts, which is 10 to 20 million per year in the model services contract and the mid-tier contract, and then a slightly lower value of 500 to 5 million per year for the short form contract, obviously reflecting the fact it's not really designed for such complex requirements. The next cap is supplier's willful default or repudiation, and I think the good news story here is that it is a cap liability, because there's always been a bit of debate in the past about, is that something that should be capped or uncapped? And as a policy perspective, should we be allowing unlimited, so a cap liability for something that the supplier's deliberately done? But where we've landed is that it should be capped, and under the model services contract, it's suggested that this is capped at 200% of the charges a year. But interestingly, in the mid-tier and short form, it just seems to sit within the general cap. So I'm not really sure why there's that variation there. And then property damage by the supplier, that's unique to the model services contract, and I think that's based on the fact that they assume that you'll have your own separate insurance policies to back that one off. And then the general cap, which is obviously the most important cap, again, it's to be determined on a case-by-case basis, but 150% of the charges per year is suggested for the model services contract. The mid-tier is slightly lower, so the 150% of the charges, but with a floor of 5 million, and then the short form contract is 125% of the charges per year. So looking at liability caps for the authority, bit simpler, but unlimited liabilities looks the same as for the supplier, and then general caps, we've got a slightly lower limit here for the authority, so 100% of the annual charges as default. So there's also been a review and consolidation of the position regarding indemnities, and these are broken down into two main caps, so capped indemnities and uncapped indemnities. And again, there's been consideration of the policy and which of the indemnities should be capped and uncapped. A few things just to flag here. So there's a few new indemnities that have been put into the model services contract in the mid-tier, and in particular the indemnity for willful misconduct or a breach of law has been added to the model services contract. That was previously in some of the lower value contracts, but not in the model services contract, and I think on review they've decided that it should be in all three contracts. But it has been clarified that this is a capped indemnity rather than an uncapped indemnity. And then 2P, that has been added into the mid-tier contract and clarified that it is an uncapped indemnity. And then authority indemnities, not much has changed here, other than the authority staff claims are now in all three of the contracts, whereas I don't think they were previously, and the indemnities are capped. Termination rights, and apologies, this is like the most hideous slide I've ever seen, but there's quite a lot of information to squeeze onto one page. So we plotted here, I think the force majeure termination rights and termination for convenience rights is consistent across the piece. What's more interesting is the termination rights associated with supplier breach for the authority. And on this slide, just to sort of explain my totally logical code, the things with an asterisk, so where the termination rights either new to that contract or has been amended in some way in the latest update, and then the blue ones indicate things that aren't in the lower value contracts. So in the mid-tier and the short form contract, there has been a change to how they deal with material breaches and persistent breaches, and essentially we tried to sort of consolidate the drafting and simplify the drafting there. In the mid-tier contract, we've got a new right to terminate for a failure to notify the authority of the occasion of tax non-compliance, and that was previously in the model services contract, but it was not in the mid-tier contract, and it's still not in the short form contract, but obviously that's just because it's proportionate to the value of the contract. And then in the mid-tier contract, there's been a change to the termination right associated with the breach of the joint control agreement. So that now has to be material, which seems like a pragmatic approach to me. And then just on the model services contract, and I think this is probably some of the more controversial changes. So we've had the right to terminate the contract where the supplier embarrasses or brings the authority into disrepute added. And equally, if there's any inaccurate statements within the supplier's tender, and as I touched upon before, I think this is one of the rights that comes up time and time again over the negotiation table, as does the right for failure to comply with environmental, social, or labour law, and suppliers really hate them because they're subjective. So it's kind of interesting that on consideration that they were kept, because I always thought that particularly the failure to comply with environmental, social, or labour law was some sort of anomaly, but still in the contracts, I'm afraid. The supplier termination rights, nothing really changed. So there's a right to terminate when the authority hasn't paid the charges, and the force majeure termination right. Indexation, so this is one of the changes that reflects the policy in the sourcing playbook, and in particular we're looking at chapter 3 of the sourcing playbook. The key thing that's changed here is that CPI has been removed as the default index. Now what we should be doing is looking at the index that best represents the cost drivers that are subject to inflation. The period of fixed pricing has also become something that the authority should insert on a case-by-case basis. And previously in the model services contract, it was suggested that that should be 2 years, but now the sort of guidance is you need to look at the particular market and sort of take your own view on that. Wording has changed in the charges schedule, so there could be increases or decreases to the charges as a result of an indexation. Previously, it seemed to refer to increases only, so that's probably good news for authorities. And then there's been some clarifications about certain types of costs which shouldn't be subject to indexation. The other interesting thing I think to draw out here is that there were representations made by the supplier community around whether indexation should be included as standard within each of the contracts. The position has always been that it's in the model services contract as standard, but it's not in the mid-tier contract or the short form contract as standard. And where they've landed on this is to sort of keep the status quo. So standard in the model services contract, it's optional, so the drafting is there for the mid-tier contract, but it's not included in the short form contract. Then intellectual property, so this is the other really big area of change, and again that's off the back of the feedback that's come from industry around the approach to intellectual property, and also off the back of quite radical sort of changes in policy positions and in the various playbooks and guidance notes. The objective here was, from the Cabinet Office, was to try to make sure that the intellectual property rights in the various contracts do what they're intended to do. And that is really to implement the policy in the Digital Data and Technology Playbook, which is that you should be considering intellectual property ownership on a case-by-case basis, and that's not one size fits all approach to intellectual property. So how this is distilled is that we've got 5 different options in the mid-tier and the model services contract when it comes to intellectual property. There's only 3 in the short form contract. Obviously it's a simpler contract, and I've tried to sort of indicate which ones those are on the slide, but the options basically range depending on how you treat new intellectual property that's created as part of the services or the supply, and who owns that intellectual property and who has a license to that property. So it ranges from a very authority-friendly position where you've got the authority owning the new intellectual property, and there's quite a limited right granted to the supplier, basically only to use that intellectual property in order to provide the services. Or you, on the other end of the spectrum, you have the intellectual property owned by the supplier, with the authority having quite a limited right to use that new intellectual property for the current contract only. In terms of what's new, there's been a fair amount of structural changes, so all the intellectual property provisions have been pulled together into a single schedule or appendix, which I think is really helpful. In the mid-tier, there were previously a couple of schedules that dealt with intellectual property, so the ICT schedule and then a standalone IPR schedule, and it was sometimes quite hard to read those 2 across onto each other, and those have been combined in the mid-tier contract and divided into Part A, which is for use when you're dealing with non-IT services, and Part B, which is for use when you're dealing with IT services. The drafting structure has changed quite a lot, and so there's a common structure in the contracts, and it divides that clearly into the different types of intellectual property, and I think that's a really helpful change. And there's been changes around terminology, so we used to talk about foreground intellectual property and background intellectual property, and this has moved to new intellectual property and existing intellectual property. Just a quick flag that the short form doesn't actually deal with IT elements of intellectual property as separate categories, so things like commercial off-the-shelf software, and if what you're buying requires this, then you probably need to consider using a different contract like the mid-tier contract. There has been updated guidance on which of the models 1 to 5 you should be using, and again this is referring out to the guidance notes that sits alongside the Digital Data and Technology Playbook, and we're going to come on to that in a little bit. There has been both guidance and drafting about contracting as the Crown, so really it's looking at what does it mean to enter into a contract with the Crown in relation to intellectual property rights, and it underlines that the Crown is indivisible. So if you do contract with a Crown body, then any intellectual property that is owned by that Crown body or licensed to them is capable of use by any part of the Crown. So it really sort of trying to draw out the implications of that when you're considering which model is appropriate. And then there's been a revision to the breadth of licenses to both third-party background, or I should say existing intellectual property, and supplier existing intellectual property. And this is sort of a tightening up, I would say, so that the license that you get is dependent on how the intellectual property is used in a deliverable. So that should be welcomed by the supplier community. In terms of which model to use, the overarching policy here is that the intellectual property should be owned by the party best able to exploit it, which a lot of the time is going to be the supplier. And instead, what the public sector should be doing is focusing on getting the appropriate licensing and revenue share rights to be able to sort of counterset any concerns they have. And the guidance points to a range of different factors that you should be thinking about in determining which model, and I've tried to sort of summarise them on this particular slide. So things like how much existing intellectual property is used. So if it was a lot based on a lot of pre-existing authority intellectual property, then you're probably looking at options 1 or 2, which is the Crown owning or the public sector owning new intellectual property. Another factor to be considered is subsidy control concerns. So if you've got a concern that allowing the supplier to keep the new intellectual property could cause a subsidy risk, then it might push you towards option 1, which is Crown ownership, or potentially any of the options, but with a revenue share option, which is option 5. Equally, if you want to incentivise supplier innovation, you're probably looking at options 2 to 5, or if there's a desire requirement to use the IP involved beyond the current contract, then you're looking at options 1, 2 and 4. But generally, there's some really helpful guidance out there really about how to sort of structure intellectual property provisions, and then the contracts themselves have quite clear drafting that implements that. And that's it. Just a couple of reflections from me before handing over to Chris. And this is sort of based on our own thoughts and from conversations with clients on the new update. So the short form isn't particularly short. It runs to 63 pages all in all, 33 of which are the core terms and about 20 of which are the annexes. And I think on the private sector side, when we talk about a short form contract, is certainly a contract for a below threshold type requirement would probably be looking at sort of no more than 10 pages. So I think there's probably a little bit more work to do on making the short form short, but equally I think this is something that the Cabinet Office is alive to and plans to do in the future. And to be fair to them, I think they did consult with industry to ask whether they could shorten it by reducing the data protection optionality and the intellectual property optionality, and the feedback from the community was no, we like it how it is. So not entirely their fault. Correct balance of risk. I think we touched upon some of those really broad subjective rights to terminate that cause so much issues over the negotiation tables. And I think I'm slightly surprised to still see sort of the really broad right around environmental, labour and equality law breaches. So I think that might be one to keep an eye on. In terms of the process going forward, the next updates are due in 2024. I think originally they had thought that they might do an update mid-year for the procurement bill, but I understand the positions now that it will be rolled up into the next annual update. And then just a final observation, if you haven't already been to the government website and had a look at the contracts, then do, because the way that they are rolling out the changes is really helpful. And essentially it's evolved over the years. We used to just get a sort of hard PDF copy of the contract and no Delta view to see the changes and no Word version. Now what we get is the PDF, you get a Word version so you can actually use it. And they then provide a Delta view showing the markup with the new changes in. There's a list of the changes, and then there's a summary of some of the changes. So there's quite a lot of information out there, and particularly if you want to look at sort of changes on a contract by contract basis rather than across the piece, that is quite a good resource. And at this point, I shall pass over to you, Chris, for an update on the procurement bill.
Thanks very much, Alexi, for that. That was superbly informative. Thank you. So, just as a PS to all that, those of you who have attended these webinars before will know that at the end of each one, as a sort of standing item, we give a kind of a little update on the procurement bill. So this is today's update, and well, basically there isn't an awful lot to say as it happens. Over the summer there have been various amendments made to the bill in the House of Commons to deal with a number of matters, some of which are, for example, sort of beefing up provisions on record keeping, by authorities for procurement purposes, provisions on strengthening exclusion and debarment of certain supplies on national security grounds, some provisions on dealing with removal of certain sort of Chinese manufactured surveillance equipment on government buildings, a requirement on authorities to make sure that they consider they safeguard the public interest in deciding, or when deciding, whether to outsource services or not. And also provisions on ring fencing money to pay suppliers in, or subcontractors in, construction supply chains, and there's more as well. So as of yesterday, those amendments, I believe, went to the House of Lords for consideration, so back to the Lords. The bill, of course, having started in the Lords, for further consideration. So that sitting, I understand, took place yesterday. That sitting has not been written up as yet or made available on the parliamentary website in terms of what the outcome of it is. So we await that. So as of yesterday, the Lords were busily considering these various Commons amendments. We'll bring you more news when we know what it is. So as of now, that is the update. We understand that the timeline for the bill being becoming live or live law is still October 2024. So there's a little while yet before the new regime actually kicks in. So when it receives royal assent, we don't yet know for sure. So again, any update on that, we'll make sure that we give you in the next the next session. So that's it from me, really. Thank you very much.
I took myself mute. That's great. And we've got a couple of questions in the chat, so I'll pick those up now as we've got a little bit of time left. But if you've got additional questions, please do sort of shout out or put them up there. So first question is around, can we add our own terms in, e.g. to reflect our policy on IR35? And I'm not sure which particular contract I was referencing at that point in time, but I think the answer is across all three of them, yes. It's probably easier to do so in some of the contracts than others. So in the modular contract, so the mid-tier contract, there will be an IR35 focus schedule, so you just need to adapt that schedule to make it reflect your own policy position. On the short form contract, the way that you add in your own positions is through special conditions. So the special conditions that can overwrite what you find in the main contract. So that's how you do that in that one. And then in the model services contract, again, it would be sitting in the schedule somewhere. So it would just be a case of updating that. I think the sort of interesting point is if you're reflecting your own policy and on an area where we know we've got this affirmative action on policy, and that you're landing on a different position to the general policy, because we know that the aim of the PPNs and the standard contract is to try to sort of give an aligned position on policy. And I don't think it's a mandate that says you can't do it, but I suspect it's like many things, it's sort of comply or explain type thing. So if you landed on a completely different position in relation to something like indemnities or termination rights, I think it would just be a case of making sure that you write your business case, so that you identify that the fact you sort of aware that you're deviating from standard policy and you've got a really good reason for doing so. So that's how I would expect that to play out. Next question was around what happens if we don't adopt these and continue to use our own templates. And I think it's probably a very similar answer on that one. So I don't think there's going to be a sort of hard line enforcement, particularly given that the PPN just says as soon as practical, and there are these exceptions, so there's more suitable contracts available, but if you come back to the purpose of the PPN, it's all about sort of creating efficiencies. And is it efficient really to have your own templates when you're going to have to update them at least once a year to pick up legislation and to pick up the various PPNs? Or is it better to migrate at some point onto the standard contracts? And again, I would have thought it gets enforced through a sort of comply or explain basis, in the same way that compliance with things like the sourcing playbook is secured. So, you know, on higher value business cases, you may find yourself having to sort of justify why you're using that type of contract over and above the standard contracts. And then the final question: the model services contract now contains an indemnity for willful misconduct. What is the legal definition of willful misconduct, and how does it differ from willful default? And I think you've really sort of hit on one of the key issues that people tend to have is with the term, because there isn't a legal definition, and it is determined by case law, and case law varies from time to time, and that's why suppliers don't like it. But in terms of where the policy comes from, obviously back when there were a lot of failing IT contracts and suppliers were walking away from contracts and basically working out that it was better to sort of stump up money up to the value of the liability cap than it was to try to continue to perform the contract. So that's kind of where it came from in terms of finding its way into the standard contracts in the first place. So I think really what they're looking for is abandonment, but in terms of how it would get applied by the court, I think there's quite a lot of uncertainty about it. So what they might like to do or look to do in the future is try to provide a bit of definition within the contract itself about what willful misconduct is and isn't, and that's certainly the approach that we've seen in other sectors and other contracts. I don't know, that's the end of the questions. I don't know if anyone else has any additional ones. Doesn't look like it, in which case thank you very much for joining us today. As I said, we will circulate the slides and the recording, and if you do have any questions, do feel free to get in contact with Chris or I, and I shall let you get back to your days. Thank you.